Ever wonder what's the difference between principal, accomplice, and an accessory to a crime? What were their liabilities and how one can be found guilty or innocent in their participation to a crime? Disclaimer: our videos on laws are based on actual cases. Any details of the plaintiff and defendant or accused offensive in any way, kindly leave a comment or message us in our Facebook, and we will be more than happy to change any details accordingly. In the case of People versus Tolentino, the accused was one of those that carried the body of the victim and even witnessed the killing. However, he was acquitted by the court, and here are the facts. On February 28, 1996, 7:30 p.m., Appellant and his cousins Sheila Gilayan and Merwin Ledesma were at their house when their neighbor Wilfredo Tolentino called them to come to his house. Once inside the house, Wilfredo revealed his plan to kill Hernan Sagario, Sheila's stepfather. Wilfredo explained that it was the only way to free Sheila's mother, Appellant's aunt, of the sufferings being caused by Hernan. 8 p.m. Hernan arrived. He went directly to the kitchen. Meanwhile, Appellant, together with Sheila and Merwin, just stayed quiet in the living room. Moments later, Wilfredo came with a 2-inch by 2-inch piece of wood, entering the house, following Hernan in the kitchen without saying a word. He immediately walloped Hernan, rendering him unconscious and falling face down to the ground. Wilfredo immediately instructed Appellant and Merwin to help him bring Hernan out of the house. Lifting Hernan out of the house, Wilfredo held him by the neck while both Appellant and Merwin grasped his feet. They then carried Hernan towards the creek about 7 meters away from the house. Upon reaching the creek side, the three stopped and moved closer to the water. At this juncture, Wilfredo successively stabbed Hernan on different parts of the body, causing the latter's instant death. After throwing the victim's lifeless body in the creek, the three immediately left. Appellant, on the other hand, both denied killing the victim. Instead, they pointed to each other as the one who killed Hernan Sagario. Fabros pointed to Tolentino as the assailant, and the latter also figured out the former as the killer of Sagario. Both were found guilty by the trial court, but they found Tolentino guilty and Fabros as the conspirator. July 14, 2000. 4 years of imprisonment. Long after the trial court's decision had become final and accusatory on his part, Wilfredo Tolentino, apparently conscience-stricken, executed an affidavit admitting sole responsibility for the death of Hernan Sagario, and retracted his testimony implicating accused appellant Jonathan Fabros. Issue: whether or not the accused is innocent based on the confession of Tolentino. Held: yes, acquitted. An appeal is a criminal action that opens the whole case to review. This implies that the court may pass upon every circumstance favorable to the accused. In People v. Manambit, the court explained thus: indeed, the Supreme Court is clothed with ample authority to review matters, even those not raised on an appeal, if it finds that their consideration is necessary in arriving at the just disposition of the case. It is a matter of justice that the two appellants would be exonerated of the charges. This we do because an appeal is a criminal action that opens the whole case for review, and this includes the review of penalty and indemnity. Every circumstance in the favor of the accused shall be considered. Even the Office of Solicitor Generals admit that the appellant did not directly kill the victim. It, however, urges us to convict him on the basis of conspiracy. In theory, conspiracy exists when 2 or more persons come to an agreement concerning the commission of a felony and decide to commit it. To prove conspiracy, the prosecution must establish the 3 following requisites. 1. 2 or more persons came to an agreement. 2. The agreement concerned the commission of a crime. And 3. The execution of the felony was decided upon. Once conspiracy is established, the act of one becomes the act of all. Well settled is the rule that the existence of conspiracy cannot be presumed. Quite the contrary, the evidence for it must be shown beyond reasonable doubt. As this court has repeatedly stated, criminal conspiracy must be founded on facts, not mere surmise nor conjectures. Prior agreements or asset is usually inferred from the acts of the accused showing concerted action, common design and objective, actual cooperation and concurrence of sentiments or community of interests. Mere presence at the scene of the crime or even knowledge of the plan or acquaintance thereto are not sufficient grounds to hold a person liable as a conspirator. Therefore, the task in every case is to determine whether or not the particular acts established by the requisite of proof reasonably yield the inference. In the case before us, we agree the culpability of Tolentino was clearly established. But we are also convinced that the evidence fails to show the culpability of appellant beyond reasonable doubt, because, unquestionably, the latter did not inflict any of the fatal blows, but he can be held liable as a principal only if conspiracy is proven. To recall, Sheila Gilain, the prosecution eyewitness, narrated the circumstances surrounding the killing of Hernan Sachario. Her testimony shows that Tolentino acted Hernan Sachario. The assault was carried out without the participation of appellant, who did not personally hit or stab the victim, but only subsequently helped carry the latter from the house to the nearby creek. Nothing in testimony conveyed a coordinated action, concerted purpose, or community of design to commit the criminal act. It must be emphasized that Tolentino's plan to kill the victim was concocted in the absence of appellant. The latter's participation, as shown by the foregoing testimony, was made when the decision to kill was already fait accompli. Further conspiracy cannot be inferred from the overt acts of appellant. He did nothing to assist Tolentino in actual commission of the murder. Neither did the former bear any weapon, much less use one to inflict injury on the victim. In fact, appellant, showing clearly lack of support for the criminal intent of Tolentino, even tried to prevent the latter from hacking the victim, according to the eyewitnesses. Indeed, the trial court based its findings of conspiracy on mere presumptions, not on solid facts, undoubtedly indicating a common design to murder. Such suspicions do not constitute proof beyond reasonable doubt. Because of the lack of united purpose, appellant cannot be considered a principal by indecisible cooperation. Absent a conspiracy, his responsibility, as well as that his co-accused is individual, not collective, and each is to be punished only for his own separate acts. Neither can appellant be convicted as an accomplice. Article 18 of the Revised Penal Code defines accomplices as those persons who, not being included in Article 17, cooperate in the execution of the offense by previous or simultaneous acts. To be convicted as an accomplice, it is necessary that the accused be aware of the criminal intent of the principal and then cooperate knowingly or intentionally by supplying material or moral aid for the efficacious execution of the crime. To consider a person an accomplice in the commission of the offense, the following must concur. 1. Community of design. Knowing the criminal design of the principal by the direct participation, one concurs therein. B. Cooperation in the execution of the offense by the previous or simultaneous acts with the intention of supplying material and moral aid in the execution of the crime in an efficacious way. And C. A relation between the acts done by the principal and those attributed to the person charged as accomplice. To be deemed an accomplice, one needs to have had both knowledge of and participation in the criminal act. In other words, the principal and the accomplice must have worked in the same conjunction and directed their efforts to the same end. Thus, it is essential that the both were united in their criminal design. In the case before us, appellant did not concur in nor lend support to the nefarious intent of Tolentino. The mere fact is that the former had prior knowledge of the latter's criminal design. This did not automatically make him an accomplice. This circumstance by itself did not show his concurrence in the principal's criminal intent. That the appellant helped Tolentino carry the victim from the house to the creek did not necessarily demonstrate concurrence of wills or unity of purpose or action. Quite the contrary. The former's attempt to dissuade the latter from killing Sachario was attested by the prosecution witness. With the dominant role appellant played in the drama that had been thrust upon him, we cannot declare that he was an accomplice in the crime charged. Appellant cannot be convicted as an accessory either. Article 19 of the Revised Penal Code defines an accessory as someone who had knowledge of the commission of the crime and did not participate in its commission as a principal nor an accomplice, yet took part of the subsequent to its commission by any of these three modes. 1. Profiting oneself or assisting the offender to profit by the effects of the crime. 2. Concealing or destroying the body of the crime or the effects or the instruments, therefore in order to prevent its discovery. And 3. Harboring, concealing, or assisting in the escape of the principals of the crime, provided the accessory acts with abuse of his public functions or when the offender is guilty of treason, barricade, murder, or an attempt to take the life of the chief executive, or is known to habitually guilty of some other crime to convict an accused as an accessory. The following elements must be proven. 1. Knowledge of the commission of the crime, and 2. Subsequent participation in it by any of the 3 above cited modes. Under paragraph 2 of said codal provision, the concealment or the destruction of the body of the crime or of the effects or the instruments thereof must have been done in order to prevent the discovery of the crime that precisely is wanting in the present case. In his testimony, appellant stated that he was afraid his co-accused would hurt him if he refused. He agreed to assist the latter in carrying the victim towards the river. The fact appellant left thereafter likewise indicated his innocence of charge. Verily, he equatantly explained his conduct prior to the stabbing incident as one born of fear for his own life. It is not incredible for an eyewitness to a crime, especially if unharmed, to desist from assisting the victim if to do so. This would put the former's life in peril. Thus, in People v. Versola, we explained as follows. It must be noted that Josepha testified that she helped her co-appellant bring the body of the deceased down the stairs because of fear. Even if she assisted her co-appellant without duress, simply assisting Versola in bringing the body down the house to the foot of the stairs and leaving said body for anyone else to see, cannot be classified as an attempt to conceal or destroy the body of the crime. The effects of instruments thereof must be done to prevent the discovery of the crime. The preassumption of innocence in favor of appellant has not been overcome by proof beyond reasonable doubt. Thus, he must be acquitted. Wherefore, the appeal is granted and the asylum decision set aside. Appellant is acquitted on reasonable doubt. He is ordered released from custody immediately, unless held for another reason. In this regard, the Director of Bureau of Corrections is directed to report to this court his compliance with this decision within 5 days from the receipt hereof.